I believe I'm now live. Okay. Welcome, everyone. I'm Ronald, the Rules Lawyer. I apologize for the 1 hour delay. People who are online often probably know there's been a new development in the D&D saga, and my YouTube is saying there is an error. So if people could say in chat whether there is some technical issue on your end or whether you can hear me. Tell me if you can hear me. Tell me the word pineapple if you heard that. Pineapple. Because my YouTube playback, okay, I see that you see me. That's good. Okay, this is a little unsettling because in my YouTube studio window it says error instead of what you guys see. Oh well. Everyone's typing pineapple. Oh, while you're typing pineapple, click like. That's going to help this get in front of more algorithms. Eyeball. Okay, great. Okay, so yeah, within the last 2 hours or so, maybe even earlier, a tweet came out that was verified by major D&D content creators, namely D&D Shorts, Ginny D, and Nerd Immersion, that this tweet, and I'm not... I just put out a video about it, but basically that that there's a plan that D&D Beyond will charge up to $30 per player for a monthly subscription, and also that top tier would give them free monthly content. And people familiar with video game monetization strategies know about FOMO, fear of missing out, having things available for a short time. Monthly content sounds like that. So it looks like aggressive monetizing is the plan for D&D Beyond. From the tweets I saw, it's not clear what the time frame would be. And I would imagine it would be with the release of the new edition in 2024. Also that... what else? OGL 1.0a unauthorized. That's no surprise. But this is tied to the OGL effort to revoke the OGL by Wizards of the Coast. And we know that the new version that they're drafting intends to push out and eliminate competition, meaningful competition in the virtual tabletop space, like Roll20, Fantasy Grounds, and Foundry, that they would no longer be able to allow people to play D&D online with their friends. Theoretically, they could negotiate their own separate license with Wizards of the Coast, but why would Wizards do that if Wizards wants everyone to have to go to them to play online? Plus, it'll be coupled with their premium character sheet generator with D&D Beyond. They basically are trying to monopolize the D&D game and derivatives of D&D. But with a monopoly, they can charge more, obviously. And also that there would be a stripped-down mode to play in this online VTT that is accommodating to an artificial intelligence. So, anyway, I don't know much about the VTT, but it seems like it would be... I'm not sure how it would be different from playing a computer role-playing game. But apparently you can talk to this thing and it will tell you things back, but it will not have anything close to the creativity, spontaneity of a human GM. I can't imagine an AI will tell a joke, for example. So I'm looking at chat. I got complaints with my last live stream. Look at the content you promised in your thumbnail now. It took me 30 minutes. I kept... I said some prepared remarks, and then I had crotch cam gate happen. If you're wondering what I'm talking about, look at my stream. Okay, what is chat saying? Yep. Wizards is going to EA itself into bankruptcy. I see that comment. But EA's not bankrupt. They'll definitely burn bridges, and I think they're counting on the new influx of people as... And as Dungeons of Discourse says in her video, which informed me about this, I'm in thanks to her, she says, well, if they're charging players 10 times as much to go into D&D Beyond, they can afford to have up to a 90% loss in players. They obviously don't count on a 90% loss in players, but it kind of tells you what they're thinking. And I think that the new players being onboarded with the D&D movie and the Baldur's Gate video game, which Wizards is counting on, is part of their math. But of course, we are mounting a campaign to cancel D&D Beyond subscriptions and disaffiliate with them and unite around the orc license so that there isn't a single dragon hoarding the treasure and hoarding the game. Yes, I see someone's mentioned cat. Yes. On avoiding the movie, should we boycott it? I don't know. I'm not for that idea at first blush, because I think that the nerd space is not going to be really registered by the overall movie execs and Hasbro. And also, if there's a campaign to boycott something, we know how that works. That might lead to more publicity of something. And also, there is it would kind of paint us in the mind of a mainstream person like, oh, angry nerds, you know? I think the thing to say is, watch the movie, look how awesome this fantasy world is, and but don't go to WotC. We don't have to. We have a very easy argument. You can play systems where the rules are free online, where you won't be having to pay $10, $20, $30 a month. That's we welcome more people coming into the hobby, and we have some easy arguments to say to get them to consider alternatives. Okay. All right, I'm gonna play this video. Legal Eagle is not someone I'm very familiar with. I think I've seen a video or two of his. He is definitely a YouTuber. He knows the algorithm. He knows D&D is a brand that's recognized, but he's also an attorney. I don't know what his specialty of law is. As you can see, I'm kind of ignorant. I'm not specialized in IP law or contract law, which are most immediately relevant to the whole OGL situation. But I think I did have a lot of useful comments in my video about from January 4th now? No, January... It was a Tuesday. It's been a lot has happened, but it was the day before the Gizmodo article came out. My comments on the OGL I thought were helpful. Another disclaimer, if you're coming to me for what do I think will legally happen with the OGL, that's not my main interest. My first interest is as a gamer. And I'm a gamer first and a lawyer second. And I think it's important to, one can prognosticate what a court will do if Wizards were to be in a legal dispute with Paizo or some other company. And however, as we know from recent Supreme Court decisions, the courts can be very messed up and abandon precedent and favor power. But I see my role as looking at the legal terrain for the purpose of activism and to protect the ability of the third parties to publish, to not have to break the continuity with D&D in order to preserve open gaming and a collaborative environment where people are not bullied out of publishing and creating their own content and innovating and borrowing from each other's content. I hope that the ORC license can be successful in uniting around itself a community of publishers who are sharing ideas and supporting each other to some extent. Of course, they'll be competing with each other, but you know what I mean. And there can't be one game that favors every single style of play. Some people will want rules light, narrative play, will want to role play as much as they do on Critical Role. Others want tactical combat simulators. We need to have a space where those can coexist. Okay. So, another preface to this is that 12 days ago I wrote to Legal. Someone had suggested, I forget where, that I should write to Legal Eagle and they should cover this. And so I wrote to them and said, hey, you should cover this, and this is going to be an issue of concern to many people, and of course, you should interview me. I never got a response, so I'm a little sad about that. But I also understand that, because who am I? I'm someone with, at the time, had 12,000 subscriptions. But now I have more. I have like 16,000. It's growing rapidly, so I'm happy about that. So he did invite Matt Colville. I'm happy for Matt, and I hope that this overall is gonna succeed at scandalizing Wizards of the Coast. Okay, I will start playing. Okay, here we go. Tell me how the sound volumes are too.
Dungeons & Dragons has altered the deal. Pray they do not alter it any further. Because for years, Wizards of the Coast, which publishes Dungeons & Dragons, has operated...
I'm sorry, I'm a little scatterbrained, and I just need to... I just produced a video, and then I just spoke to all of you, and I've been multitasking all day, and I get into brain space to focus on what I'm listening to, and start over. Here we go. Dismiss the pinned message. Oh. Okay. Anything else I should know? How was the volume? Oh yes, Minsk was great from Baldur's Gate. I loved Minsk. Okay, good.
Dungeons & Dragons has altered the deal. Pray they do not alter it any further.
Wait, what is this? Original Gaming License 1.1? Anyway, that's not correct. It's Open Gaming License. Anyway.
Because for years, Wizards of the Coast, which publishes Dungeons & Dragons, has operated under an open gaming license, an OGL, that allowed people to create and profit from unofficial content in the Dungeons & Dragons universe. Or does it? It's time to think like a rules lawyer. The idea
Hey, me! He's trying to think like me. Oh, and also that was a joke, because, D&D players have rules lawyers.
Is a legal framework that allows people to use the rules and ideas of the role-playing games to create their own works. And it was originally released in the year 2000s by Wizards of the Coast, and a lot of people have come to rely on the terms of the OGL to make and publish their own content.
Level 10 lawyer, civil litigation. That's cute.
Under the aegis of Wizards of the Coast. But that was version 1 of the OGL. Now, according to a leak, version 1.1 of the OGL, which has not officially been adopted, makes huge sweeping changes that will affect anyone that makes content even related to Dungeons & Dragons. But this leaked version 1.1 update to the OGL is a mixed bag. It purports to crack down on sexist, homophobic, and transphobic content that is created with the Dungeons & Dragons name. It purports to grant a perpetual license to Wizards of the Coast for anyone that makes content using that license. It purports to require certain people who make content for anyone that It purports to grant a perpetual license to Wizards of the Coast for anyone that makes content using that license.
That was not a complete sentence by him. Wizards of the Coast gets a perpetual license for any... Anyway, you all heard it. That wasn't... It wasn't saying the point, which is to use the content that people create.
It purports to require certain people who make content using that license to report that usage to Wizards of the Coast. And if you make over $750,000 in revenue, you have to pay certain royalties up to 25% to Wizards of the Coast on certain marginal income.
Certain marginal income? I don't know what marginal income means, but my understanding from the reading was that it's on all income above $750,000.
These are big changes. Now, it's important to distinguish the OGL from the actual Dungeons & Dragons rules. The Dungeons & Dragons operates under a set of rules that's up to version 5e at this point, and the OGL is not the Dungeons & Dragons
5.1.
rules. And generally speaking, those rules are found in
version 5.1. Sorry, I'm finding these little details that a fact checker would have found. Sorry. I am a OCD rules lawyer. A little bit OCD.
And the OGL is not the Dungeons & Dragons rules, and generally speaking, those rules are found in the System Reference Document, the SRD. That's a 400-page document containing just about everything you need to know about playing D&D. The main benefit of the OGL, whether you're talking about version 1 or version 1.1, is that it allows people to use and reproduce the SRD, the rules. But for people who make content that just simply works with the rules but doesn't reproduce them, well, there's a big question.
Works with the rules and simply doesn't reproduce them. I'm sorry. I want to be careful.
It's making a distinction. That's up to version 5e at this point, and the OGL is not the Dungeons & Dragons rules, and generally speaking, those rules are found in the System Reference Document, the SRD. That's a 400-page document containing just about everything you need to know about playing D&D. The main benefit of the OGL, whether you're talking about version 1 or version 1.1, is that it allows people to use and reproduce the SRD, the rules. But for people who make content that just simply works with the rules but doesn't reproduce them, well, there's a big question about whether you need the OGL at all.
Yeah, this was a question I was having up until the leak came out. Because when you read it on its plain terms, it says you can use and reproduce this text under this license. And that's what this license governs. But I had been wondering, and part of it too is, I'm not claiming to have come into this with full knowledge and omniscience, and maybe chat could even help me. If I produce a subclass for D&D 5e today that is entirely unique, it's not, I'm sorry, a new class. Say a new class. It uses actions and bonus actions. It refers to spells from... I'm sorry. What if it says it just has the same spells as the wizard spell list? Okay? Let's say I publish that. I'm not reproducing any text from the player's handbook, nor am I reproducing it. There's another word in the SRD says it governs the use of the content. Am I using the content by making something compatible with the content, or that can be used when someone runs the game? On that, I'm not sure. And so I was thinking, okay, what is an analogous situation? Could I use, can I create an expansion to Monopoly that doesn't use the word Monopoly? And let's say has some stickers you can put onto your game board on different effects that happen when you land on Boardwalk or on Parks Place. Could I do that? And I don't know the answer to that. I know Monopoly would be like suspicious of you and would maybe send you a lawyer letter, but I don't know where the courts would fall on that. So let me see if chat has anything to say on that, because I would like to be clearer on that before watching more. Tater Raider says you are creating a dependency. Yeah, what I produce would be dependent on the main thing, and arguably I'm not challenging the sales of the main player's handbook. If anything, I'm enhancing the sales of the player's handbook by advertising that not only is there a player's handbook my content is compatible with, but it must be really good if I'm making content to expand on it, and I view it as, a market leader. Someone writes, I saw Cory Doctorow write about this, that the OGL allows the reproduction of game concepts that you do not necessarily need permission for, with allows in quotation marks. Reidling Jr. says they don't think there is precedence. And I think the allows in quotation marks means that the OGL kind of allows something that, even in the absence of the OGL, might already be allowed. So it looks like this is a gray area. Right. D. Waisley says the OGL maybe not be needed, and I would add in certain cases, but it does make things more clear and removes questions like this. I mean, there's a clear statement of intent. Okay, apart from the words, we also have to look at the context. Wizards of the Coast in 2000 was telling people, and I saw the Ryan Dancey interview, they recruited specific companies to be third-party publishers and made sure that they were released at Gen Con, the same Gen Con where Dungeons and Dragons was released. And so there's they're showing through their actions, this is acceptable. You can make things, adventures, a monsters tome that are compatible with our product. And they partnered to demonstrate that. So I'm not saying the OGL specifically was needed for that. Actually, I may be mixing issues, but because was the OGL needed for that to be possible? Well, the clear intent was to make it clear that those companies and everybody can do so without fear of being sued by WotC. I think that's the point I was on. Yeah, I recommend the Ryan Dancey interview to everybody. Okay. Someone, okay. Here we go. Keep going.
Now, we'll come back to that later. Now, these sweeping changes caused a huge uproar among fans and content creators alike. But like I said, it's a mixed bag. On the plus side, it provides a relatively clear path to allow almost anyone to create officially licensed content, and that's pretty rare. It's not like Disney says, sure, you can make any Mickey Mouse content you want, just pay us if you happen to make over $750,000 in.
That's not a perfect analogy, because Mickey Mouse is arguably... It would be the equivalent of us using Drizzt for Forgotten Realms, right? That was a crude analogy. I don't know, maybe trying to tailor it for... I read that, and I saw when I was skimming through the timeline that Monopoly does come up on the screen, so maybe I'll talk about that there. But I don't think that was a very precise statement. Oh, another thing, too, on whether one can still produce content that is compatible with, let's call it 6E. I also saw Questing Beast's video saying you don't need the OGL. I do think, though, that the wizards we are seeing through their public statements is going to... I don't see them not going after people trying to republish 3E rules or old school Renaissance, older edition rules. So whatever the language says and whatever the legal precedents are, and apparently this is, according to one comment, there isn't a legal precedent for making... sorry, I'm losing my thought. We know WotC's intention. And so anyway, I'll keep playing.
Revenue. And if these changes were coming from a position of absolute restriction, like Disney has a lockdown on their IP, then people would probably rejoice that they have this pathway to make officially licensed content and profit from it. But as it stands, we're coming from the opposite.
I'm sorry, I'm pausing. What we're dealing with is probably copyright expressions with game rules, and but Mickey Mouse is both copyright and also a trademark, I would say, of Disney. So anyway, sorry.
Then people would probably a position of absolute restriction, like Disney has a lockdown on their IP, then people would probably rejoice that they have this pathway to make officially licensed content and profit from it. But as it stands, we're coming from the opposite. We're coming from a world where almost everything was totally open, and these restrictions are causing a lot of consternation. So many people are upset about this leaked modified OGL. And the leaked OGL differentiates between commercial and non-commercial content. People making non-commercial content are fairly unburdened. And the leak says that making money via Patreon doesn't necessarily count as commercial. So that probably covers a large swath of people who might otherwise be upset about these changes. Now, I'm not going to dive too deep into the changes of this OGL. It's reasonably easy to understand to the credit of the lawyers who drafted it, and a lot of the coverage has already described what the implication of these purported changes are. And there are some issues as far as enforceability and promissory estoppel and reliance. Can you revoke a license that was granted in perpetuity? I'm not going to get into those. For a more detailed breakdown of the contractual provisions themselves, I'd highly recommend you check out the nerds over at Opening Arguments. They really go into the details of what the original and the leaked OGL say and what they don't say. It's absolutely the best breakdown of the contracts themselves. But I also think almost everyone is missing the biggest issue. And what I want to cover today is one of the more fundamental flaws with this whole setup, and I think, frankly, it changes everything. And as it happens, this whole controversy is a perfect opportunity to teach people about the difference between copyright and trademark. So, you know, win-win. But the original OGL has been around for a while, and it was intended to provide an open platform for players. And for some of the critical background on that history, I turn to the D&D expert and uber nerd, Matt Colville.
The products that they make for Dungeons &
Okay, I'm not sure where he's going yet, but I, as part of researching for this live stream, I was referred to that podcast by those two lawyers, and it was terrible. It was horrible. It was kind of an actually from by lawyers towards Linda Codega and her Gizmodo article that broke the news to a broader audience and kind of analyzing her language, and it was very pro Wizards, and it and kind of assumed some benign intentions by Wizards. And anyway, I don't have clear commentary on that, but let me see what comments there are in chat. Yeah, Opening Arguments really missed what the controversy is about. That is true. I see that comment by Alexandra D. Archangel. Because if it were... they missed the boat. And if... what people have been outraged about is having their content stolen by Wizards and having the royalties taken and having to register and the terms changing at any moment. And none of that was retracted in Wizard's statement on Friday. Those are the hot issues. Those are the real issues. And also, Opening Arguments did not know the history of them giving a very clear impression that OGL, that most things generally would not change for third-party creators. And that being completely different, giving a completely different impression from the OGL they tried to push through. I'm sorry. As I said, I was kind of scatterbrained. He's not going to go after is it revocable or not. Legal Eagle. He seems to be moving past that, which I think is a shortcoming, because I think there's going to be a battle for survival for many publishers who want to continue to have something very 5e-like or something compatible with 6e, and also for Pathfinder 1st edition and 3rd edition creators, and for the OSR. They're going to be sued by WotC. There's going to be some legal battle, and hopefully they can unite together so that they can do that. So let's see what else this is going to cover. Okay.
Dragons tend to sell best.
Win-win. But the original OGL has been around for a while, and it was intended to provide an open platform for players. And for some of the critical background on that history, I turned to the D&D expert and uber nerd, Matt Colville.
The products that they make for Dungeons & Dragons tend to sell best to players. Well, adventurers don't make a lot of money because only one of the 4 or 5 players at the table buy them, but you still got to make them. So his argument was, why don't we open these rules and make it so that anybody can make products for us, and that way third-party companies will come along and they will make adventures for us. And they'll make other stuff too, but we don't care. And that way they'll support our product. And there was also some verbiage in there about how, and if those companies improve our rules and it's published under the OGL, then we can take those improvements, right? And then our game will improve. And that was a very egalitarian way of looking at things. And then fast forward, and Wizards of the Coast releases a 4th edition, which was very controversial and alienated a lot of fans. And so they sort of freaked out and released a 5th edition.
Sorry, just one thing. Just on him moving past the controversy dealing with, the survival of certain publishers. This video is very much intended towards the non-D&D audience. There's just a lot of basic info that people who have been following the controversy already know that we're seeing so far. So he's, in critiquing this video, we should keep that in mind. It's for the general public.
The edition wasn't released under the Open Gaming license. It was released under a different license called the GSL, which was much more draconic and restrictive. And then 5th edition was released under the old OGL, which is much more open and broad and empowers people to make the stuff they want. Privately, the reason Ryan said he wanted to talk the board into opening D&D was because he did not like the idea that any one company would control this hobby. Like, he was like, I think D&D should belong to everybody, and this is the best way I can think of to make that happen. D&D is, I think, more of a folk tradition and a hobby than it is a classical brand. And it has always relied on the people who play it, more so than any other game I can...
That was well put by Matt.
Classical brand. And it has always relied on the people who play it, more so than any other game I can think of, except, perhaps like Skyrim, right, where there's so many mods for it. It's always relied on the audience to create content for it. Things like The Thief come from people playing in Los Angeles and coming up with a new class and literally calling up Gary Gygax on the phone and saying, hey, we got this cool idea. And he's like, oh, that's cool. I'd probably do it like this. And
yeah, the AD&D was just putting together all these dragon articles and things by other zines, things that were catching on into a single tome. Yep.
All of a sudden, there's a thief.
Like the Ranger and the Bard also had their versions in Dragon magazine
cool
before.
Idea. And he's like, oh, that's cool.
AD&D.
I'd probably do it like this. And all of a sudden, there's a thief in the game. Right? So that relationship between the players and the people making the game has always been a lot more gray and weirdly nuanced than almost any other game I can think of.
Okay, so with that background out of the way, let's talk about the difference between copyright and trademark. I promise it will be worth it.
I'm sorry. Does he... This is going to sound cruel, but it's like a staff wrote the script for him. Someone else interviewed Matt. I mean, it was clear I don't see any questions posed by him to Matt. And I just feel like, anyway.
So with that background out of the way, let's talk about the difference between copyright and trademark. I promise it will be worth it. Now, copyright is a certain legal protection for expression. When you have an original work of authorship, whether it is a movie or a novel, and you affix it to a tangible medium, well, then copyright will protect that expression. Copyright does not protect ideas, it does not protect processes, it protects expression. Whether that expression is in the form of words, or a painting, or a video, copyright will provide quite a lot of protection. Trademark is about serving to identify the source of a particular product or service to distinguish that product from other sellers in the marketplace. The idea with trademark is you don't want consumers confused. You want people to actually know what they're buying at the time of sale. And trademark is a little bit different in that it can last forever. As long as someone is actually selling the trademark good, that trademark will continue for the protection of consumers. Now, Dungeons & Dragons as a tabletop RPG product involves both. It contains copyrightable pieces of expression, as well as trademarkable elements that are meant to identify it in the marketplace. Let's use a board game that everyone is familiar with, Monopoly, as an example here. The name Monopoly is trademarked. There is a long history of the Monopoly trademark that dealt with years and years of litigation. Let's put that aside for the moment. The logo of Monopoly is also trademarked. The official Monopoly board, the actual squares and everything on it, that's copyrighted. That is expression. It's as if it were a painting. And then sometimes within board games, you have specifically detailed characters that can be copyrighted. For example, in Monopoly.
Okay, sorry. I just feel like this is... I'm going to
Uncle
keep playing.
Pennybags is a copyrighted character, and in Clue you have Colonel Mustard. Those are copyrighted characters.
I'm only a guest.
But the name of the game, Monopoly, is trademarked. So you can't go out there and create a game called Monopoly and sell it, even if the rules of the game are completely different. But what about the opposite? What if you created a game that had a different name but followed the same rules as another game? Well, that takes us to the fundamental flaw of this whole entire controversy, which is that you can't copyright the rules to a game. You can't copyright a process. Now, this goes back to an extremely old copyright Supreme Court case in the late 19th century called Baker versus Selden, where someone tried to copyright a particular method of bookkeeping. In that case, a guy created a method of bookkeeping, i.e. accounting, and published a book about it. The book did okay, but it really took off when another person created another book of basically just forms that used the same methodology, but didn't credit the original person. The original author sued, but the Supreme Court said that there was no copyright available because you can't copyright a method. And that idea was later codified in the Copyright Act of 1976, which said, quote, "In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described."
Let me just read this language more carefully. In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. So in my mind, I see this as, particular expressions of an idea are what can be copyrighted, but the actual idea itself cannot. For me, the analogy I'm thinking of is science. You don't want the idea of Newton's laws of physics to be not used by other people for obvious reasons. In dealing with understanding our reality around us and solving practical problems, we want science. It's in the public interest for science and the ideas that science produces to be shared and then innovated upon and challenged. I kind of feel like game rules are kind of like that. I feel like game rules are tools that allow people to engage in a game of imagination that has some game element to it. And it's unlike a board game, it's always kind of evolving table to table. Sometimes you have a book that has a set of rules, but then someone else might iterate on it. So that for what game rules, for the purpose of what game rules do, it's in the interest of the hobby around these rules to have to share them and have them be open. Okay, let me see what the comments are saying. Oh, we have 476 people. Welcome, everybody. Subscribe while you're here and press the like button, please. Okay, well, this is a gray area because let's say WotC does its tries to shut the door on third-party publishers publishing. What if people do not go with sign the OGL? Could they produce something that has ability scores called strength, dexterity, constitution, etc.? It would be an interesting lawsuit first of all, I don't know if it would ever come up in a lawsuit because everyone would probably play it safe and say might, agility, simply because those are not claimed by someone who has a lot of money who can sue you. But then, what about other concepts like hit points being depleted and then you are unconscious when you go unconscious? I don't see how they can make a claim to that. And that's actually something from that podcast that they list among things that WotC could sue over. Which just tells me again that podcast, they're not completely right on everything. Bob's hand, I see. Okay, I will keep playing.
And illustrated or embodied in such work. So, for example, if you wondered why everyone could play the game Words with Friends on Facebook, even though it was an exact clone...
Yeah, I'm sorry. This is less about D&D and more about giving people a lay understanding of the law, which is a public service. More people should understand these strange words that lawyers use, but it's clear this is more of a general legal educational channel,
Play the game Words with Friends on Facebook, even though it was an exact clone of Scrabble. Well, that's the reason. Scrabble can't have copyright protection over the rules of the game. It can only really get trademark protection over the name Scrabble, not the rules contained therein. Now, there is a little bit of a wrinkle here in the sense that if you had a manual of rules, you do get a thin copyright over the exact expression over the rules as laid out in that rule book. However, you don't get a copyright over the rules and processes themselves. So in a sense, you can have something that has exactly the same mechanics, the same processes. It just can't necessarily have the exact same expression if you were to reproduce the rules perfectly. But that's kind of a minor quibble. So how does this relate to the Wizards of the Coast update to the OGL? Well, I think, and I could be wrong, that Wizards of the Coast is assuming that anytime anyone creates any content that happens to use the rules of Dungeons & Dragons, that it's covered by the OGL. I don't think that's the case. Now, this is not legal advice. Your mileage may vary. But as we discussed, you can't copyright the rules. You can't copyright the methodology and processes. And that takes us to the thing that no one is talking about. Here's part of the secret. The original OGL kind of sucks, and here's why. The main benefit of the OGL was that it allowed people to include the SRD, the system reference document, in their material. If your material doesn't require a reprinting or quoting of the SRD or the 5e rules, then you probably don't need the OGL. The original OGL allowed people to use what it called, quote, open game content, meaning, quote, the game mechanic and includes the methods, procedures, processes, and routines to the extent such content does not embody the product identity. Now, it did not allow people to use, quote, product identity, meaning, quote, product and product line names, logos, identifying marks, including trade dress, artifacts, creatures, characteristics, stories, storylines, plots, thematic elements, dialogue, incidents, language, artwork, symbols, designs, etc., etc., etc. So based on what we've already discussed here, I'm not sure that there was much benefit to the original OGL. It mainly allowed you to use stuff that you were already allowed to use, unless you wanted to actually quote the expression that was found in the SRD itself. And the new OGL does basically the same thing. The leaked OGL allows licensed people to use, quote, licensed content. It says, usable D&D content, quote, licensed content. This is Dungeons & Dragons content that is included in the SRD version 5.1, including basic game mechanics, a curated selection of classes, monsters, spells, and items that allow you to make content compatible with Dungeons & Dragons 5th edition. And then the new OGL goes on to say, not usable D&D content, quote, unlicensed content. This is Dungeons & Dragons content that has been or later will be produced as official, that is released by Wizards of the Coast or any of its predecessors or successors, and is not present in the SRD version 5.1. Unlicensed content includes things like the most famous Dungeons & Dragons monsters, characters, magic spells, and things related to the various settings used in Dungeons & Dragons official content over the years. What the old open licensed content referred to as, quote, product identity. So both OGLs purported to let you use game mechanics of Dungeons & Dragons, and in my view, that's stuff that everyone was always allowed to use. But of course, the benefit of the OGLs, whether it's version 1 or version 1.1, is that it provides certainty. So there's that. But let's differentiate between two different types of content. In one bucket, you'll have what I'll call reproduction content. And in the other bucket, you have what I would call homebrew content. In this first reproduction bucket, you have things that would probably be considered from a copyright perspective derivative works. That is, works that are based on a copyrighted property that Wizards of the Coast owns. So for example, if you made a t-shirt that features a character that is based on an official Wizards of the Coast Dungeons & Dragons campaign, and you put that on a t-shirt, even if you paint it yourself, well, that's probably a derivative work. And you need to get the permission of Wizards of the Coast. And to their credit, Wizards of the Coast has a fan art policy that allows fans to create fan art. And this is on their website, and I don't think it's changed. But also in this bucket is stuff that reproduces the SRD. Remember, I said that they do have a copyright over the actual exact wording that's in the SRD. And recall that both the original OGL and version 1.1 allow people to reproduce the SRD. So if your livelihood relies on actually reproducing the expression of the SRD, you would need to abide by the terms of the OGL. And I don't think that has changed. And maybe you want to quote large sections of the SRD to put it into a reference manual, or maybe you want to put the entire SRD into a PDF along with your original content. Say if you created an entirely new set of rules, but it starts with a basis of the SRD and you don't want to have people referencing back to the old SRD, well, that is probably covered. And to their credit, both versions of the OGL allows people to do that if you want to quote the SRD. It creates a pathway for that. But this reproductive bucket consists of things that are based on things that Wizards of the Coast can actually copyright. In the second bucket, and this is the thing that I think most people are upset about, would be homebrewed adventures and campaigns whose only connection to Wizards of the Coast is the fact that they use the rules in Dungeons & Dragons 5e. In this bucket, I'm kind of thinking about the things that you see on Critical Role or Dimension 20, where they create a campaign that is 100% original. The characters are completely new. The settings are completely new. And the only...
I'm sorry, but the draft language kind of... I'm sorry, calling it a draft is a misnomer. The language they tried to get away with 1.1 is purports to go after to prevent people from making videos that use the rules. And so, what does that mean for YouTube content creators or live streams? That seems really a stretch. So we'll see.
Connection that these campaigns have to Dungeons & Dragons and Wizards of the Coast is that they rely on the rules that are set out in Dungeons & Dragons 5e.
Like, if we were playing Monopoly, could Monopoly sue me? If I were... that just kind of... Obviously, they can't, because... it's just an interface in which we're playing a game. It's an interface for our social interaction. It seems like you can't... because, like I said, the purpose of these laws is to protect the creation and innovation of ideas. So, does me producing a live stream playing D&D threaten their bottom line? No, it doesn't. If anything, it's advertising their game. And so I think there are some things that they actually they would be stretching if they try to do that through their legal documents, but also they may not even go after them in reality because they actually help the brand. And so I'll say more of my thoughts after, but it seems like what people are outraged over is something is not really touching, which is the monopolization of D&D Beyond and actively trying to shut down supplemental content, which I don't have a thought yet on where they stand in relation, whether they can continue to do so. Things like extra classes, campaign settings.
The connection that these campaigns have to Dungeons & Dragons and Wizards of the Coast is that they rely on the rules that are set out in Dungeons & Dragons 5e. As we discussed, I don't think Wizards of the Coast has much protection over the rules themselves, the processes and methodologies contained in the Dungeons & Dragons rules. So if you create an otherwise original campaign, where the only connection is the fact that it uses the rules that are set out in D&D 5e, I don't think that runs afoul of the OGL. In fact, I don't think you need permission from Wizards of the Coast in any case. Even if you videotape and live stream that campaign, I don't think you need their permission. Because at the end of the day, Wizards of the Coast doesn't really have any kind of IP protection over the rules themselves. Now, admittedly, there's a lot of gray area here, because it's not as simple as one bucket for fan art and one bucket for homebrew. Wizards of the Coast in D&D has all kinds of different characters. Some are pre-made. Now, arguably, those characters are often in the service of the mechanics of the game. They define the strength or speed or dexterity of these particular characters. But there's also backstory there. So does that create the kind of character that is protected like Colonel Mustard or James Bond? Or is that simply a rule in the game that functions within that rule-based universe? That's a tough question. But I'm also skeptical that the changes to the OGL affect virtual tabletops or Kickstarters as well. Again, the virtual tabletops are basically using the mechanics of the rules themselves, which I don't think Wizards of the Coast has much protection over. And
there's one issue here there's a legal issue of whether Wizards can claim copyright violations by VTTs and these other things he's talking about. But let's get real. That's kind of how the terrain is. That's how it's fought. That's the legal question that's fought. That would be fought. The question is, does something is it a competitor to Wizards? That's the issue that Wizards cares about. So the VTTs are competitors to what Wizards wants to do with One D&D. A book that makes a set of monsters that's better than the monster manual is a competitor to D&D. Those are the kinds of things that that's the practical. We kind of can't really look at these things in isolation as without looking at the real battles between companies and how the law's applied.
Same with Kickstarters over original campaigns and adventures. Again, if you're creating an entirely original world that just simply happens to use the rules of Dungeons & Dragons, I'm not sure that there's much that Wizards of the Coast can do about that. Though, at the same time,
right.
If you are trying to do a Kickstarter over something that Wizards of the Coast actually has protection over, if you wanted to crowdsource a movie based on the mythos and lore of Dungeons & Dragons, that probably is going to be covered by the OGL. Though another gray area where I'm not sure where a court would come down would be, say, live streaming a playthrough of an official Wizards of the Coast Dungeons & Dragons campaign. Obviously, Wizards of the Coast publishes a number of official Dungeons & Dragons campaigns, and if you live streamed you and your friends playing through that, that is using official Dungeons & Dragons content over which they do have the copyright. That's a tough call, though I would say that's
Yeah, and there I think it's less tough than he's saying, because you're not threatening their bottom line. You're not you're advertising their product. Your thing is not in competition with something else that they put out. So
analogous to live streaming a playthrough of a video game, which is also kind of a gray area. A video game is copyrighted, and it's an open question whether your playing through it is adding a...
Okay, and on that, do video game companies actually sue people for streaming? I think they don't. Maybe Nintendo does. Nintendo's notorious, and partly that may be because Japan's laws are different. Let me see what chat is saying. There's some people in chat talking to each other. Watsy, a comment about Watsy not going after the OSR. The OSR is operating in a different space and probably isn't on Watsy's radar screen. It's probably a tiny audience, yeah, compared to what Watsy's thinking about. However, I see them suing because they can. They have the resources to win on the principle. But if it's something... anyway, I need to think a little bit more about what about the actual battle that's going on with this OGL that they want to put out and what's at stake after watching this. Hold on.
Enough original content to be covered by fair use. And the same would go for playing through a Dungeons & Dragons official campaign.
Oh yeah, fair use. Sorry, I forgot about that. That's an exception. You can reproduce copyrighted material if it's under this broad concept of fair use. It's like an exception. It's a defense to a copyright accusation in U.S. law. If you're commenting on something, that's a classic protected thing due to the First Amendment. Okay. The DO sues streamers who watch and react to a television show or movie because it can hurt their sales. I don't know who DO is, but yeah, you cannot reproduce... when you react to a movie, you cannot have the movie on. And the reason is obvious. Someone can choose to watch your video reaction, arguably, to enjoy the movie, and therefore that takes a sale away from that movie company. But I don't think that's true with a game, showing people playing a game. Again, I hate using Monopoly as an example because I like hobby board games. You can see from my shelf, and Monopoly is not the best game out there. But yeah, just can you sue people for playing Monopoly? I don't think so.
I would question whether your playing through it is adding enough original content to be covered by fair use. And the same would go for playing through a Dungeons & Dragons official campaign. Though I do think that is a separate question from the kind of fully original homebrew type of situation that we were just talking about. Now, if you are a big player in the space, like Critical Role or Dimension 20, there might be some true advantages to making sure that everything is officially licensed by Wizards of the Coast, and they might not be able to avoid it. And certainly, if you are going to create your homebrews that are not officially licensed, you can't say that they are officially licensed, and you probably can't use the name Dungeons & Dragons, except in a nominative or descriptive fair use way, in the sense that you might be able to say something like, this campaign is compatible with Dungeons & Dragons, because even with trademark restrictions, you can describe a thing by its official name. But you're likely to be able to compare stuff and say that this is compatible with the rules of Dungeons & Dragons. You're just not allowed to say that this is from Dungeons & Dragons or somehow officially licensed. Anyway, that's just a theory. A game legal theory. And, of course, the situation has now changed. Wizards of the Coast released a statement on dndbeyond.com on January 13th.
Sorry, I'm just laughing because a lot of people had to, put little appendices to their videos lately. There's something happening every day.
Wizards of the Coast released a statement on dndbeyond.com on January 13th. In a tongue-in-cheek way, they said that they were cognizant of all of the pushback and, quote, rolled a 1. They say that, quote, the next OGL will contain the provisions that allow us to protect and cultivate the inclusive environment we're trying to build, and specify that it covers only content for TTRPGs. That means that other expressions such as educational and charitable campaigns, live streams, cosplay, VTT uses, etc. will remain unaffected by any OGL update. Content already released under version 1.0a will also remain unaffected. What it will not contain is any royalty structure. It also will not include the license back provision that some people were afraid was a means for us to steal work. That thought never crossed our minds. Under any new OGL, you will own the content you create. We won't. Any language we put down will be crystal clear and unequivocal on that point. Now, not only have I been talking to tons of D&D players and GMs, I've also been talking to Wizards of the Coast lawyers. Now, there's tons of stuff going on behind the scenes, but all the lawyers will officially say is that their statement is sincere. Typical lawyers, just the worst. But look, it's great that they listen to the criticism. I'm sure that the changes will mollify a lot of what people are currently upset about. But I think the point remains.
I don't believe he talked to Wizards of the Coast lawyers.
People are currently upset about. But I think the point remains. If you're only making content that is D&D compatible and doesn't reproduce their IP, well, maybe you never needed to comply with the OGL in the first place. Maybe the real OGL was the friends that we made along the way. Smoke bomb! Now, normally I would not cover a topic like this. This is way too nerdy, even for me, and it's way too in the weeds. Normally, a subject like this would be covered by fellow YouTube attorney Richard Hoeg. A few days after Christmas, he suffered a stroke, was rushed to the hospital, and underwent extensive brain surgery. It seems like he's through the worst of it, but regardless, he's going to have an extensive recovery period. And Richard has always been a straight shooter, and his YouTube channel, Hoeg Law, has always been a resource for insightful legal commentary on a lot of legal minutia. And his channel, as many of you know, is focused on the gaming and video game industry, things that Richard is incredibly passionate about. This is exactly the kind of video that he would have loved to have made. If he'd been able to. His road to recovery is going to be long. His sister has created a GoFundMe page called Reasonable Minds Can Rebuild, because one of Richard's famous phrases is that reasonable minds can differ, because he wasn't afraid to offer an unpopular opinion, because reasonable minds can differ, especially when it comes to the law. And that's always been an incredibly admirable trait of his. So I'll put a link to his GoFundMe page down in the description and up on screen. If you're able to support it, it would mean the world to me so that we can speed along his recovery, because legal commentary on YouTube is just a little bit dimmer without his contributions. And then, of course, he can deal with all these friggin' nerdy questions about Dungeons and Dragons and Wizards of the Coast. Bunch of nerds. Cool kids play Magic.
Okay. Yeah, despite what I said about its limitations being more about general legal education, he does raise a good point about going after WotC's one of their main contentions, can they own a mechanic? Anyway, I think that's worth raising. I was hoping he would go after WotC, but that's kind of not his shtick. He's more of a general education legal channel. I want to kind of gather my thoughts. Let me see what chat is saying. Okay, yeah, so let's just kind of think back to where we are. So the last 22 years, it's been clear that people can do quite a bit to publish under for D&D 3rd edition and 5th edition, as long as you don't say Dungeons and Dragons or use the various things listed as product identity under OGL 1.0a. And what's the issue is right now, though, is tying yourself to this OGL and having your stuff taken from you, having to pay royalties, and under terms that WotC can change at any time. So companies have to consider, do they want to get into that at all? Because when you sign something, you kind of arguably are ceding some points, whatever it says in the contract, including the or just go ahead and, like, should the OSR just publish things independently and see what happens in the legal realm after. I think in general there's going to be some kind of court battle. Paizo may be involved because they make Pathfinder 1st edition, and the OSR, they kind of reproduce rules that are arguably based reproductions or close to the SRD. I'm sorry. Again, I'm scatterbrained and stressed out. Let me read chat, and my thought will come back to me. But yeah, I do think in general that I like the concept of the orc license that was announced by Paizo, because, like I said earlier, I feel like game rules are kind of like comparable to science and us collaborating to make tools for most fun. You need an open collaborative environment so that people can, borrow things like the 3-action economy, which I said WotC should steal, and other companies should steal for their designs. But also that games, tabletop games, different groups want different things from from RPGs. And you might want a game like Powered by the Apocalypse that puts narrative front and center and allows players to construct, to be actively building the world and making up things and having a dialogue with the GM. Or you want something that's like, a judge, like a combat simulator, which is a set of rules to, play the game on a battle mat. Or you want some kind of hybrid. For there to be one company that purports to have the one system that accomplishes all of these things is not true. And then for them furthermore to try to crowd out everybody else but them so that we all have to go to them and pay, up to $30 a month. That's just not right. All of these ins and outs about, is this a copyrightable expression or is that, and what is the meaning of this word? Is perpetual, does that mean it's irrevocable? Those kinds of questions are important, but also there's the overall concept of intellectual property law of fostering the production of ideas for the benefit of society, and balancing that with the private interests of those who create those ideas to have some right to what they created for a while, so that there is more incentive for future individuals to make more ideas and then make some personal profit, but not at the detriment to society. There's a balancing act. And I think in the TTRPG space, you can't own this hobby. It doesn't make any sense on a common sense level, and it's going to be limited what Dungeons and Dragons in the end is going to be able to do with its shenanigans. So I'm looking at chat. Jeremy Tuttle says for him, Legal Eagle's point has been the thing he's most interested in. WotC cannot earn our trust back, so what all can we really take from them? Orc Revolution is really where his head is at and what he's interested to see. Yeah, because it would really be something if out of the Orc license, there's all these companies that are successful, and Paizo, with its system being arguably among this family of companies around it, if their system, Pathfinder 2e, is arguably compared to whatever Kobold Press would put out, let's say it's arguably the closest to the the SRD, the 3rd edition SRD. Would Wizards really want to sue Paizo and claim that Pathfinder 2e is a copyright violation? Completely aside from whether that's good legally, that's a completely bad PR move. You're kind of looking like you're bullying a competitor because their system is something you cannot compete against. There's a reason why you're trying to silence this particular system and make it not a competitor. It would draw a lot of eyes towards Pathfinder 2e, even more than there is now, and make people be like, how similar is it, and how is it different? And it would even be a factual issue at trial. How different is it from the 3rd edition SRD, and does it innovate? Does it improve upon it? And those are the kinds of questions WotC would not want to come up in a big public trial. Okay. Yeah, but yeah, it is the big crisis is that, Wizards is telegraphing that if you want to continue to publish stuff that's compatible with them generally, you have to agree to these hostile terms. And what I've not heard of anybody who would actually sign any version of them, and a lot of trust is lost now. I think that's just the immediate situation right now. I don't know if they'll have to say that they are not revising anything except to add irrevocable to 1.0a, and sure, being more explicit against hateful language, which arguably 1.0a already allows Wizards to prevent third-party publishers from doing, and for them not to go after. Well, I'm not sure about VTTs, whether going back on that is necessary to get print publishers to make a piece and sign something for Wizards. But in the absence of that, we're just going to be in a situation where people need to put out their own stuff. I saw a comment worrying about the fragmenting of the community. I don't know. I don't know about that. I think arguably we were seeing that few things have united the community as much as recent events. Sure, there may be different systems, but I think it's an overall plus because people will be outside of the mindset that there's only one default game and look around. And I think that before 2000, that was kind of the terrain. That was the RPG world. There were just many systems out there on shelves. And I don't think that's a bad thing. Yeah. How much for the Ronald VTT? I don't even know what that could possibly be. Oh, I should point people to check out another video on my channel, which is the Beginner Box Weekend that we are organizing on the Rules Lawyer Discord server, where already we have 60 GMs who have signed up from all time zones. If you want to play Pathfinder 2, or even if you want to GM it, because the beginner box can be run out of the box. It's that easy. And if you want to GM it, and also we have a drop-in play system to play Pathfinder 2, where you get to have consistent characters level up between sessions. So this is your chance if you've been looking for a group to play Pathfinder 2 with, or at least to try it out, to try out the Beginner Box Weekend. Oh, I got a YouTube chat. Thank you, Great Role Playing Debbie. Hot take: AI DMs are bad, equal bad, only if get uber capitalized. Let's more extreme styles of play, therapy games happen. Also, nerd friends hard to find. Yeah, I'm not in principle against AI. AI DMs, it's more the attitude Wizards has that they can they have this whole attitude that they're going to get a huge growth with the movie brand, with the brand growing with the movie and stuff, and that they don't need to make tools for DMs to run the game, because that's been one of the huge complaints about D&D 5e, that it doesn't give support to DMs, and for them to just be, for part of the reason for that being that they're banking on a computer to do that, is really angering to me. DMs should get more support from Wizards, and sure, not everyone's going to have a DM all the time. But no, it's not that I'm per se against AI game mastering. It's what I'm saying. Tater Raider is asking, how are they teaching the AI DMs? Third-party materials? I do not know. I don't know how these AIs work. And they can do some pretty amazing things. And it sounds like a crazy thing to us now, but I saw a video about it. I forget what they were called. Something Barbarian. that who had looked at how AI develops in other areas, that just give it a few years, it's going to do some things we cannot believe today. Thank you, Outsider, for the $5 donation. You should talk to Nick Rakita and Runkle of the Bailey Roll of Law on a stream over this. Okay, I'm going to write those names down. I don't know who they are yet. Nick Rakita, Runkle, Roll of... Wait, are those two people with Roll of Law? Okay, and also I should check... I'm sorry, I don't know... I have to go to a separate place to see if anyone donated on Stream Elements. I doubt it, because I didn't put the link to the tips there. Okay, what else? There's a question. Can they add irrevocable without changing the version number? No, they would have to. It's the nature of the version number that you would... in order to prevent confusion... you would want a new version number, but it could be 1.0b. It doesn't have to be 2.0. Okay. Sorry, I'm managing stream, looking at chat, also trying to get my thoughts together. Poor Kid says 6E will be a bigger disaster than 4E was. I think that's where we're headed, unless they turn around. I think things are getting more... The fact that they've lost a bunch of faith of the community actually means the more time passes... I don't know. I'm sorry. At some point, they may conclude they're never going to get people back. And at that point, they're completely face towards all the new people and to hell with the current group. And maybe they're already acting that way. What's the ratio of GM to players for Beginner Box Weekend? When I last checked, it was 2 players per GM. So we actually have a GM excess currently. It kind of goes to show that a lot of people attracted to Pathfinder 2 are the GMs looking for a more GM supportive game. But also there's just a huge lot of people in the Pathfinder 2e community that really want to teach the game to others, that are who were already kind of evangelical before. I use that word specifically because they really like the game and want to share it with others, who are now fired up by WotC's recent actions. So yeah, we can handle more players currently. I saw another comment from CH Joe. Thank you for organizing PF2 games. You're welcome. Okay. All right. So, do I have any other last thoughts? I should probably stop the stream and get back to my other work. I don't know. I just, on the question of can people publish stuff compatible with One D&D, 5e, and 6e, I think that, okay, this is what I think. If it's in print, I don't think WotC will care that much. If it's something that does not threaten a sale by WotC, it arguably helps them. Something compatible, that's an expansion to 5e and 6e. I think they will go after people who try to reproduce rules, like the old school Renaissance. But if you're trying to... The very fact of how the VTT works means that you'll have to have some agreement with them to create something that is within their walled garden that you can use in One D&D. And they may or may not allow that at all. And so, because a lot of people use D&D Beyond for their character sheets, and expect that convenience of having something digital that you can access from anywhere to run your adventure from. But so that's my very hazy guesses, because in terms of campaign settings, other stuff in print, they have offended the big publishers already who have been like been a significant competitor to them. I think they're already moving away. But for those that might produce some options for 5e or 6e in the future, I think that in print, I don't think they will really care. RP Gamerus, have I listened to the Opening Arguments podcast about the OGL issue? It really left out a ton of important context. I read their show notes, and I wrote some thoughts on it. I was very angry when I read their thoughts, which I assume they read out during the podcast. My thoughts are kind of scattered. Sure. The thing is, responding with a more focused video would take more time. And I apologize for this reality, but yeah. So if that's it, I should probably go if people are saying that. Okay. Anyway, continue the conversation. Join the Discord server to participate in the Beginner Box weekend, and also in general, and you should support Orc. All companies that are producing things under the Orc license, Paizo included. So that includes Green Ronin Games, Chaosium. We need to support those companies that are committed to having an open environment for games. So on that comprehensible note, I would like to end. Thank you, everybody, for tuning in and being patient with me. I know I've been somewhat scatterbrained, but 430, 550 people tuned in, so I'm honored. Honestly, it is just a real challenge producing content. I have a brief due on Friday, and it gives me less time. Ideally, I would have had an hour to organize some thoughts together, but I just didn't have that time. Okay. All right, then. Orc. See you all later. Let's chat some other time, and join my server and subscribe. Thank you very much.